Welcome, everyone. Thanks for coming. This is the final in the Carr Center series on the Obama human rights policy, the unfinished agenda. And we couldn't ask a better person to be our grand finale. I want to introduce very briefly, because I think many of you know of Harold Koh, but Harold is professor of law at Yale University. At one point, he was the dean of the law school, and he assures me he's glad he's not anymore. He resigned as dean to be the State Department legal counsel, head of a massive legal office overseeing American foreign policy from a legal point of view. And he left that position just a year ago. It was April in 2013. Before that, among other positions, Harold was the Assistant Secretary of State for Democracy, Rights, and Labor in the last 2 years of the Clinton administration. He served in the Office of Legal Counsel in the Reagan administration. He also tells us his first trip to Guantanamo was 1991, where one of his first famed comments was a discussion of Guantanamo in regard to Haitian refugees was a rights-free zone. And that's been something he battled for many years, which had, I think, some bearing later on both how people thought about Guantanamo and he celebrated, as many of us did, when the Supreme Court decided it was, in fact, not a rights-free zone. So one of the foremost legal scholars on human rights, a person always of great interest to talk, a terribly dedicated Red Sox fan, and a very good friend to all of us in the human rights movement, Harold Koh. Thank you.
So it's great to be here at the Kennedy School and at the Carr Center. It's particularly great to be here with Catherine and Doug, who are old friends, and with many other old friends as well. What I wanted to talk about today was Obama's human rights policy and what I will call strategy, issues, and unfinished business. And it will be sort of kaleidoscopic as a way of giving you a lot of different issues. Let me just say up front, I'm not going to talk about unfinished business, which I think will not happen. So, for example, I think obviously the United States should advise and consent to the Convention on the Rights of the Child, or the Convention for the Elimination of Discrimination Against Women, or the Convention for Disabilities, or the Tobacco Framework Control Treaty, but it probably won't happen. And so given that there's limited political capital, what are the things that are actually achievable, and how do you push for them? My own history, as Doug said, is that I've spent about now more than 30 years as an international law professor, 5 as a dean, 20 as a human rights lawyer, and then 10 years all in the U.S. government. Just to give you some illustrations, this is the UN Human Rights Council in Geneva, where I presented the U.S. Universal Periodic Review. This is at the Nuclear Security Summit in the Kremlin. This is Bagram Air Base in Afghanistan. This is Guantanamo, one of my numerous visits there. This is Iraq, the Greek financial crisis in front of the Parthenon, with Secretary Albright in Korea at the funeral of Kim Dae-jung, a great hero of mine. I appeared in many courts. I argued for the United States in the Kosovo case at the International Court of Justice, European Court of Human Rights in Strasbourg, African Court of Human and People's Rights in Tanzania. I was the co-head of our delegation to the International Criminal Court. This is the most famous. We were going into Libya after the fall of the of Gaddafi, and we were in Malta, and they got this military transport, and you know, in the middle they put in these 4 nice seats, and so Secretary Clinton and her staff person were in the front, and I was in the back with Jeff Feltman, who now works for the UN. And we all started texting, and you know, people came and started taking our pictures, a little embarrassing. So I actually texted to Secretary Clinton, look over your shoulder. That's what she's reading on this text. It's the only known picture of her texting. It's become iconic, and it's on her Twitter site. And then, you know, Bill Clinton recently actually photoshopped himself into this for his Twitter feed. But the important thing is I'm still there. And my mother loves this. She's like, oh, everywhere I look, there you are. No. I worked on many issues. Here is Chen Guangchen, Chinese human rights activist. I spent several weeks in China getting him out, and he's moved to the United States since. 9/11 occupied a huge amount of time. WikiLeaks, Haitian earthquake, Fukushima power plant meltdown, obviously Arab awakening, human rights issues, International Criminal Court, cyber issues, economic and private international law, environmental issues, and public health. And I played a number of roles. I was a managing partner of a law firm at the State Department, about 205 lawyers, about 350 people. I was a counselor to the secretary, so a general counsel, just like a general counsel function that you could play at any agency or a private corporation. I managed conflicts among different parts of the State Department. It's a far-flung operation, but I think the unique function of the legal advisor is to be the spokesperson and conscience for the U.S. government on international law. My view was the U.S. shouldn't take a contested international legal position without putting the position out there, whether people like it or not, so people at least understand what our international legal position is. But if we were sued, as we frequently were, I'm the defender. And so that's why I was before all the courts. I was also on every U.S. brief challenging international issues in the domestic courts, etc. Now, here's my brother, actually, Howard Coe. He's the Assistant Secretary of Health and Human Services. He's the highest-ranking health official in the U.S. My mother loves the picture because she thinks Obama is working for us. She always says, oh, show me the picture again of how Obama is sitting below you guys. My brother actually was a professor at Harvard Medical School and the Harvard School of Public Health. He was Commissioner of Public Health here in Massachusetts before moving to Washington. And we spent many hours. This is the first time we worked in the same place since high school. So we've had a lot of conversations about the lessons we learned in the government. And there are basically 4. The first is, you know, you're not the only lawyer. So there were 200 plus lawyers in my office. Guess how many lawyers there were in the Defense Department?
1,000.
How many?
I guess 700.
Probably 17,000. 17,000. How about 11 to 13,000 in the Justice Department? National Security Council, CIA, Treasury, Commerce Department, U.S. Trade Representative, and after each one legal position. And obviously they're reporting through chains of command. But that ought to give you a sense that it's not that easy to come to a single view. And in academia I love it. They say, you know, the government legal position, when it got to the interesting questions, they didn't clarify them. Well, guess what? That's where they stopped agreeing on what the position was. You know? So it's amazing there's a position at all. Second, you know, you're not your own client. This comes as a great shock to people. You know, I wrote many articles and books, and I would read in the blogs, what Coe said today cannot be squared with this footnote in an article he wrote when he was 28 years old, coming up for tenure at Yale Law School. Well, first of all, it can be. Never has the blogger actually read the article. So it can be squared. But more fundamentally, the people in my office, their job is not to read my past writings. their job is to read the precedents of the office of the legal advisor. And there's a rule of stare decisis that's followed. And you can change it, but it's not changed lightly. And why on earth would you consider that in considering a question of national importance that has arisen again and again and again, that you look at a throwaway footnote in a 28-year-old guy's tenure piece, as opposed to the considered legal view of thousands of lawyers in the U.S. government working on the issue in a situation of life or death. And frankly, 33 years later, I know more than I did then. So anyway, I consider this absurd. But in academia, it applies, it's all gotcha. And it's also all without ever actually reading the opinion. You know, they pick out a few words. More fundamentally and shockingly this, my view is not the one that counts. Your client's view is the one that counts. Get that, you know? I work for Hillary Clinton. She's an outstanding lawyer, really superb, brilliant lawyer, shockingly good lawyer. I mean, her speed of uptake is phenomenal. Obama, not a slouch. And if they want to do something, my job is to tell them whether I think it's legal or not. It's not to tell them whether that's my preferred alternative among legal alternatives. Now, obviously, if you think that torture is being proposed and you think it's illegal, you say it's illegal. But if you think there are a bunch of legally available options, you say, I don't like that option. It's what we call lawful but awful. But if you select that option, I can defend its legality because I think it's legally available to you. Third, you have many roles, as I described. And finally, you have to play the hand you're dealt. You know, so you know, everyone aspires at Kennedy School of Government. You aspire to be in the government. And, you know, when you go into the government, what's it going to be like? Answer, I want to be the legal advisor of the State Department in a time of perpetual peace and prosperity, you know. You know, great. Guess what? You know, you come in and it's the worst financial crisis since the Depression, and we're in the middle of 3 wars, and then you throw in a few earthquakes and natural disasters, and then put WikiLeaks into the mix as well, and a bunch of other things. And there's a story, the 2 guys from Galway walking down the road, and one of them says to the other, how do you get to Dublin? And the first guy goes, I wouldn't start from here. You know? So guess what? You wouldn't start from here, but you know, you don't have that choice. You play the hand you're dealt, tough, and make the best of it. But I say this because the people who have been in the government and know this story. You know, you come into the academic environment, and to me it's like watching a baseball game. You know, I can say, haha, Derek Jeter didn't get to that ball. He must be washed up. But the truth of it is, I couldn't get to that ball either. So it's a very difficult game to play, lots of impediments. The interesting thing is under public scrutiny, but nobody knows the pressures that are actually going on. So I'm much more, I think, respectful of even obviously botched decisions that are made, because I understand how they came to be made the way they were made. So I consider myself to have had the exact same commitments in many different roles. So I am a man of peace, I'm a professor of international law, I'm an advocate for human rights.
Sarah.
But this shouldn't be a mystery. You know, if you do criminal law, you might spend part of your life as a prosecutor, part as a judge, part as a criminal defense lawyer, part as a professor. You might emphasize different aspects of the exact same field of law, but there's no guarantee, but you're playing a different role. So if you're a defense lawyer, you're going to identify and invoke different cases than if you're the prosecutor. That doesn't mean that you've sold out. It just means you're playing a different role in the same area. Now, now my PowerPoint went away.
Wait, are you trying to work on the mic?
Yeah.
Oh. Sorry.
Let me go back. Yeah. So why do I say this? Because another thing I'm sometimes asked is, you're a human rights lawyer, you criticize torture, and you defend drones. And, you know, killing people is worse than torturing them, so you must be a hypocrite. And my answer is no. The truth of it is all torture is illegal, no matter when it's used and under what circumstances. In warfare, torture is illegal, as well as in peacetime. Under the laws of war, some killing is lawful. I'm sorry, that's what the laws of war is about. And it is a job of lawyers to draw the line between lawful and unlawful killing. I thought the killing of bin Laden was lawful. I didn't rejoice in it, but I didn't think it was illegal. Were his human rights violated? Probably. Was he himself a massive human rights violator? Surely. So, isn't this exactly what you want lawyers in the government to do, to draw these lines? And so again, you have to basically understand the roles that you play and understand at what point you're speaking as a lawyer, at what point you're speaking as a human rights advocate. Now, the question is this, and I'll put it this way. My very first day on the job, somebody came to me and said, guess what? The frozen embryo of a large marsupial is being held at the customs station near our embassy in country X. And the question is entitled to foreign sovereign immunity under the Foreign Sovereign Immunities Act of 1976. And it occurred to me that the framers of the Foreign Sovereign Immunities Act, or the Convention on Foreign Sovereign Immunity, had not considered this question. And more than that, it occurred to me that, in fact, we weren't going to get an answer from normal lawmaking processes. You know, the United States cannot ratify treaties these days. In fact, they can't do legislation. They have all the difficulty in the world, even not defaulting on our debt. Nor can Congress pass statutes. So we're in a situation where we have 21st century problems and 20th century law. And the question is, what do you do about it if you're the lawyer? And I think there are two possibilities. One approach is what I call the Turner Doctrine, Tina Turner. What's law got to do with it? You know, what's law but a sweet old-fashioned notion? It's a black hole, right? It must be a rights-free zone. The Geneva Conventions must be quaint. Now, my argument would be that this is the strategy. And it's before we go into particular cases and unfinished business, we have to talk about whether there's a strategy that is being applied so you understand the cases where it's misapplied. And I think the strategy is international law as smart power, which has three simple elements: engage, translate, and leverage. Engage means when in doubt, engage with other interested parties, public and private, to achieve an outcome. Translate means when in doubt, don't use a black hole approach, use a translation approach. And leverage means when in doubt, use legal rules and international law as a element, sounds familiar, and then you're replaced by another hegemon. So my view is that a smart power approach is not only a viable approach, it is the only viable approach going forward in a world in which nobody has supervening power. Now, where did this come from? Oh, by the way, obviously, engage, translate, and leverage is in contrast to the last administration's approach, which is unilateralism, black hole, and going it alone, or not. I think this is a failed strategy. I think the other strategy has potential, but it has to be implemented in the proper way. Now, where did this come from? Obama in his inauguration said this. A new era of engagement, respecting laws, living our values doesn't make us weaker, it makes us safer and stronger. I put this picture in memory so you see how much younger Obama is. These jobs kill you. Hillary Clinton coined the phrase smart power. She said exactly what I just said. People thought it was a slogan. But if you Google Hillary Clinton smart power, you'll see that she has dozens of speeches from the time of Secretary of State. You know, there are these people now. Hillary Clinton has no philosophy. Well, you obviously weren't paying attention. Hillary Clinton has smart power in public-private partnerships, smart power in internet freedom, smart power in economic statecraft, smart power in counterterrorism. Every single dimension of her approach was couched in this language. Engage, translate, and leverage. Now, let me just apply this strategy to 6 areas, and then in each area I'll talk about the unfinished business. Human rights, criminal justice, public health, emerging technology, cyberspace, and elements of 21st century war. So let's just take Burma. When we came in, Aung San Suu Kyi was under house arrest. Option 1, do nothing, don't engage. The alternative, engage with her, engage with the former SLORC, SPDC, engage with those around the Burmese government in the region, engage with the Chinese, develop a strategy called Action for Action, which is a way to ease sanctions that were imposed combined with monitoring of corporate conduct, and try to leverage the progress that you make on a case-by-case basis into a broader framework for building rule of law and human rights in Burma. And guess what? Aung San Suu Kyi is now a member of the parliament. She is the head of the Rule of Law and Human Rights Committee of the parliament, and she's running for president. Or if there's constitutional reform, she could be president. Well, let me take another one. The clearest example I can think of in Gates translated language. The United States was not a party to the Human Rights Council, which was created. They pointed to its flaws. These flaws are indeed manifest. But we decided we would run, and we ran for re-election and won again. We started to use the Human Rights Council as a forum. So, Hillary Clinton goes to the Human Rights Council meeting in Geneva. She could have not gone. That's non-engagement. She decided to go. She decides to give a speech, and in that speech she says LGBT rights are human rights, and human rights are LGBT rights. She went and got this issue. And that's a pure act of translation. What you've been thinking of as human rights includes the rights of LGBT peoples, she says. So that entire apparatus that was constructed to protect traditional groups applies equally to this group. Where'd you get this? Beijing Women's Conference 15 years earlier, women's rights are human rights and human rights are women's rights. A pure translation exercise. And then when you combine this with a bunch of domestic initiatives, elimination of don't ask, don't tell in the military, same-sex benefits, Supreme Court initiatives with regard to the Defense of Marriage Act, the whole marriage equality movement, and you have a sea change in the human rights of LGBT people in the United States. Well, how about this? Chen Guangchen, lying Chinese activist, barefoot lawyer, trapped in his home in Shandong, escapes, comes to Beijing, calls and asks to come into the U.S. Embassy. A non-engagement strategy is, I'm sorry, we can't help you, or we have to help everybody. Another is, don't talk to the Chinese about this. We decided to engage both, Chen and the Chinese. What about the translation? Does he have a legal right to enter the embassy? No. But my call, sitting in Chongqing, China, was, can the U.S. legally admit him for short-term purposes for medical care? Yes. So that's a translation. And then we leverage this with private institutions, their NYU, to bring him out of the embassy first to the NYU campus in China, and then eventually to the NYU campus in New York. And I'm happy to say more about it. Now, there's obviously unfinished business. Central African Republic, which is a prime minister of your former director Samantha Power, my friend. South Sudan, Sri Lanka, which is an effort that has been picked up again by the Human Rights Council, as you well know, was initially bungled, but really through persistence in going back at this issue, a strong resolution was recently achieved. Issues of North Korean human rights, Iran human rights obviously being now the next step after an Iran nuclear deal. And I can say more about this. Territorial application of the Covenant on Civil and Political Rights and the Convention Against Torture. When, as the United States said recently in Geneva, these treaties stop at the water's edge, that means what happens outside is a black hole. And my view is there are no black holes. So these are important issues. The CAT meeting where the U.S. will have to present its position on the extraterritorial application of the Torture Convention is in October, and that's a big moment. What about international criminal justice? Well, here was an odd asymmetry, which is that the United States
brought the first international criminal prosecutions in Tokyo and Nuremberg, prosecuted for a series of crimes. Then in the 70s, participated in the resurrection of ad hoc tribunals in Rwanda, Yugoslavia, Sierra Leone, Cambodia, but then opposed the International Criminal Court. So we had this completely ridiculous position where the U.S. supports the ad hoc tribunals and opposes the standing tribunal that's about to supplant them. And also, there are a series of laws passed by our Congress, the American Service Members Protection Act, which actually makes it illegal to support the ICC with funds. So I'm put in charge of this situation with Steve Rapp, my colleague. And our approach is, we will change the policy without changing the law. I said to my son, do you remember the time we turned the car around inside the garage and didn't open the doors? That's what it's like. It's very simple. Engage, translate, and leverage. We went to Kampala for the review meeting, we went to The Hague, went to New York. We made it clear we did not oppose the object and purpose of the Rome Statute as opposed to the Bush administration, which had famously unsigned it under John Bolton. And most importantly, we support all pending prosecutions, including the referral in Libya. So the policy has now changed to one of positive engagement with the court without changing any laws. Engage, translate, and leverage. Now, what is the unfinished business there? Obviously, both the Kenya and the Libya prosecutions are in deep trouble. The African countries hate the ICC now. The Libya case has become an embarrassing collision between a fledgling Libyan democracy and a fledgling international criminal court, which ought to be avoided. I mean, you want the international criminal court to get strengthened. And the looming battle, the crime of aggression, which was adopted at Kampala in 2010, but put off for implementation till 2017, if adopted, could be used to chill humanitarian intervention. And thus, ironically, the tool of international human rights will actually become a deterrent to legitimate action to prevent human rights abuses. Many countries are just simply ignoring this problem. It's something that in a rational worldview would address through a strategy. And in fact, 2017 is too far away for most countries to address it. How about this? Public health. Suppose we uncover the practice that contributes to 5 million deaths annually, rise to 10 million a year, 100 million in the 20th century, causes a death every 6 seconds, and will kill 1 billion people in the 21st century, mostly in low and middle income countries. What am I talking about? Smoking. Smoking. Shouldn't this be treated as a human rights violation? I mean, people talk about 171 people in Guantanamo, and they don't talk about smoking, which is commercial entities addicting children and killing them for a profit. And they've been doing it for a long time. And don't we have a moral, if not a legal obligation to respond? Shouldn't we have a strategy to promote global public health? 50 years ago, the older people that remember the Beatles were Sullivan, Lyndon Johnson, Nelson were poverty. The Surgeon General announced the link with cigarettes and cancer. The crisis is getting worse. It's now the largest cause of non-communicable diseases, 5 million deaths annually. Tobacco consumption doubled. Non-quitters die 13 years earlier. It costs $200 billion in added health care costs. And the Surgeon General's report saved 8 million lives, but 400,000 Americans still die prematurely. 600,000 die globally. This is my brother, Howard Coe. So here we are again. So we have decided, my brother and I, how many years do we have left? Let's just work together on this one. He'll do it from the public health side, I'll work on it from the human rights side. And get this on the map. And you may have seen yesterday, finally the Food and Drug Administration has brought e-cigarettes under their jurisdiction. Very important step. This affects the Trans-Pacific Partnership. It affects investment treaties where the tobacco companies have very aggressively brought suits against Uruguay, Australia for their plain packaging laws. It's a issue on which public health people are extremely knowledgeable. International law people don't think of it as a human rights issue. Human rights people don't act like it's a human rights issue at all. My argument would be that there's a human right to avoid preventable, non-communicable disease caused by addiction promoted by under-regulated private production and consumption. And if you accept that notion, there are a whole series of steps that a government may take in the name of the human rights of its citizens. So normally you think of government regulation as the thing to which human rights responds against, where here it is government regulation that could save many people's lives. How about this one? Just to show you I'm not making this stuff up. Lesbian mother implanted into her womb is a fertilized egg in which neither the sperm nor the egg are from an American citizen. So the mother is American. The fertilized egg is not from American sources. She's married to another lesbian who's not American, and she's living in a foreign country. She carries this baby to term over 9 months and delivers it in the foreign country. Is that child American? Or, as the laws argue, is that child stateless? Because they define a natural relationship, which is what the law requires, as genetic. And my interpretation was translation. Natural could mean genetic or it could mean gestational. And carrying a baby to term of 9 months in the womb creates enough of a natural relationship. It's good enough for me. Not black hole. By the way, this created a firestorm. But I think it's a much bigger issue. This is one of the subjects of my future research. Maybe somebody in this room is a clone. Or maybe not. But maybe you were born by artificial insemination. Somebody? Are you telling us? If that were known, are you a lesser person? Are you not entitled to human rights? How about this? Is everybody here entitled to have a clone of themselves developed, and then as they get old and sick, mine that cloned person for spare parts, and leave the other parts of it on life support, so that you go back and get their liver, and go back and get their brain? And guess what? Do we want to think about this when it's a live possibility, or do we want to think about it now? Or will we treat clones like bastards, or people of different sexual orientation, or disabled persons, or other lesser individuals? And by the way, who's thinking about this? Again, this is being thought of as a technological issue, not a human rights issue. And if there's a theme of this lecture, it should be this. Technology is way ahead of human rights law, and we better catch up. How about this? Cyberspace. Now, cyberspace has 4 prominent dimensions: internet freedom, intellectual property and piracy, e-commerce, and cyber war. There are many others. The interesting thing is that the Universal Declaration of Human Rights actually anticipated by saying you have a right to seek, receive, and impart information and ideas through any medium regardless of frontiers. And Secretary Clinton gave a strong speech favoring internet freedom. But guess what? Internet freedom can be used for, planning terrorist attacks, money laundering, etc. So how do we address this issue? And this is what's come up in the issue of surveillance and privacy, in which there are a lot of very simplistic points of view. But the question I would ask is, to what extent does our technological capability determine our responsibility and authority? It used to be we didn't know what people were plotting on the other side of the world, and we do now. But the fact that we can now detect it electronically, does that give us a right or a responsibility to address it by drones? Or should we just wait until those people come to our shores carrying bombs in suitcases? It's a tough question. Or the Fourth Amendment standard, the Supreme Court doctrine, is reasonable expectations of privacy. What are your reasonable expectations of privacy? And do people actually think that when you're sending an email on Gmail that no one's going to read it? I don't think so. Or do you think that it won't be subject to a government subpoena? I think it's subject to a government subpoena. Or what about the fact that people are voluntarily giving huge amounts of information to third-party providers and think they're not giving it to the government in some way? Now, that's not to defend government collection of bulk data. I mean, it turns out that the government was massively collecting bulk data without having any idea what it was going to use it for, and so Obama has now called stop to that. But notice this, the exact same people who are terrified of the NSA think that Health and Human Services is incompetent to run a website. Right? So which is it? The government is all-powerful and omnipotent, or they're incompetent? I don't know. And then the solution, privacy advocacy as human rights advocates, the Privacy and Civil Liberties Oversight Board. There are efforts to now try to generate a system of internal checks and balances, which is really just getting off the ground. These are some of the issues that are involved. And there's a lot of posturing this. Does Angela Merkel really not know that her phone is being listened to? You know, give me a break. On the other hand, does that mean that anyone's entitled to listen to anybody's phone? No. So this is a complex balancing exercise that needs to be treated in a much more subtle way. And frankly, I'm surprised at the level of lack of subtlety by which it's being treated by academics who should be the most subtle. How about cyber conflict? Again, cyberspace is increasingly used for warfare. And here's my question. Does some guy sitting at a computer terminal in Fort Meade at Cyber Command hitting a key that sends across borders, are they subject to the Geneva Conventions or not? I'm sorry, the Geneva Conventions framers did not think about that question. So, it's a translation versus black hole. The United States has announced a policy of translation and attempted to set forth a series of principles. The main one, cyberspace is not a law-free zone, which is exactly the point that we made about Guantanamo some years ago. We've tried to embed this into diplomatic discussions of the group of governmental experts, the World World Conference on International Telecommunications, and tried to leverage it into a series of standard-setting exercises. Meanwhile, China asserts there is no law in cyberspace. Or how about this? Most 21st century war will not be conducted by soldiers. It will be conducted by people like Arnold Schwarzenegger. No, not as governor of California. Isn't that amazing? Arnold Schwarzenegger is governor of California. I mean, it is amazing. Now, of course, he's returned to his original job, which is actor in new movies, which I watch with great interest. The Expendables 1, The Expendables 2. And the question that always crosses my mind is, do these guys have to follow the Geneva Conventions? Or if you completely outsourced all military and special ops operations to private contractors, do you therefore escape the laws of war? So one of the efforts that the U.S. launched, along with a group of other like-minded, is the Montreux document, a binding statement of principles and practices, translated into a code of conduct. 500 plus companies try to internalize these norms into contractual behavior through private contracts. My own approach to law is internalization of norms, so this is very much in line with that. What are some of the unfinished business? The ambassador will recognize this as from the CCW agenda. Landmines. You know, the United States could get to accession to the Landmine Convention. It's a challenge. I know Samantha Power is deeply engaged on this. The autonomous weapons issue, which is coming before the CCW in May. Again, the territoriality of the ICCPR on some of these issues, and then a general debate about the relationship between international human rights law, international humanitarian law, and the so-called international law of lex specialis. It's a technical issue, but I'm happy to discuss it. I'm just getting started here, but here, how about Arab awakening? And as these different countries in different ways started showing a breakup of authoritarianism, I remember Secretary Clinton said, you know what I see? And I said, what? And she said, they don't want to join Al-Qaeda. In other words, the breakup of autocracies could lead to people regaining control over their own lives if we can get them to discredit extremism, embrace human rights, and engage in political participation. So her speech on the 10th anniversary of September 11th was pretty simple. use force for limited purposes within a broader framework that employs diplomacy, development, education, people-to-people outreach, and challenge ideology, propaganda, and appeal. Smart power. But there is an element of hard power that is part of this broader approach. Osama bin Laden is not going to suddenly become a Democrat. He has no political aspirations. This was entirely misunderstood, and on the same day she gave his speech, Benghazi, that's all anybody talks about. So what about drones? Here's a thought experiment for you. You know, the Academy is obsessed by drones. To which, let me suppose the following had happened. 7 days after September 11th, let's suppose the president was the person who won the popular vote. He comes out and he says, last week we faced the largest attack on civilians on U.S. soil since Pearl Harbor. More than 3,000 people were killed. That's a massive human rights violation. We have to respond within the law. I'm going to adopt an engage, translate, and leverage approach. And here is what I'm not going to do. I'm not going to invade Iraq. I'm not going to torture or waterboard anybody. I'm not going to engage in extraordinary renditions. I'm not going to set up military commissions. I'm not going to open Guantanamo. But if Osama bin Laden and the other key leaders are in a cave in Tora Bora and there's no other way to get them, it's been authorized that I can use force against them under U.S. domestic law, and it's consistent with the laws of war. And if I need to take them out with a drone, I will. I'll do it transparently. I'll define the standards by which I do it. And I'll ask for your support. And I hope it's over soon. Would people have really said that the drones were the problem? You see my point, which is the mistakes were two. One was doing all the things that we never should have done. And the second was coming in, as Obama did, not immediately changing this. The net result of which is we are now stuck in a situation where people are so confused by our drone policy, they think that the drones themselves are the problem. To which my response is, if you fixate on drones, you're fixating on a remote technology, and the history of warfare is remote technology. And by the time the next set of drones that get launched 10 years from now will be taken out by cyber command, not by drones. So while you're obsessing about drones, the law of war issue will have moved on. So what to do? How about this? See the counterterrorism issue as a broader smart power approach. Engage, translate, and leverage. Drones are a tool, not the strategy. It's part of a much broader approach to ending the war with Al-Qaeda and the Taliban. That means engaging with our allies, translating legal rules, using limited uses of force with other methods to address the broader problem. And finally, President Obama went back and embraced this approach completely a year ago at the National Defense University. He said, we have to define the struggle or it'll define us. There is no global war on terror. We have to end the forever war. We need to repeal the authorization for use of military force. And then he defended drones as part of a smart power approach to dismantle specific terrorist networks that threaten the U.S. So what's the unfinished business? Number one, transparency. Obama could have built a lot more support for this strategy by acknowledging what the U.S. had done before instead of pretending that people couldn't figure this out. Second, consultation with Congress and our allies. And third, standard setting with our allies to try to get to agreed upon legal norms. And the key was his focus on ending the war, an exit strategy rather than a perpetual war strategy. He linked it it can be linked to the drawdown in Afghanistan, which is occurring as we speak. Sunsetting the AUMF. Congressman Adam Schiff has made proposals on accountability, for example, transparency requirements, various review processes, scope reforms, for example, authorizing elongated self-defense by statute, codifying the presidential policy guidance preferences for law enforcement and capture solutions over killing. All of these are part of unfinished business. And it can all be done in the context of a much broader effort to end all three wars, Iraq, Afghanistan, and Al-Qaeda, by declining military engagement, continuing civil engagement, developing civil society, and ratcheting up diplomatic engagement. And the key, I think, is this. If we're at war against Al-Qaeda, the Taliban, and associated forces, then the question is how to negotiate with the Taliban. That takes them out of the equation. How to define associated forces narrowly so everything that sympathizes with Al-Qaeda is not treated as Al-Qaeda, and defeating Al-Qaeda core and its core elements. And that means a statement that we're not at war with everyone who hates America, because a lot of people hate America. We're not at war with ideas, religions, propagandists, and journalists. And self-radicalizers are subject of law enforcement, not the laws of war. You know, the Sarnaev brothers in Boston sympathize with Al-Qaeda, but they're not members of Al-Qaeda. They can be dealt with through law enforcement methods as they are being, the younger one is being dealt with through law enforcement methods. What about closing Guantanamo? Again, about 150 people remain. I can talk through the various strategies, but it means giving more political impulse, doing a review, transferring those who are cleared to transfer, negotiating a block transfer with Yemen, trying those who are triable, releasing those who are releasable. And my own view is that Obama can get to zero, but it'll probably be at the very end of his term. And finally, the difficult one. The other ones are easy. Humanitarian intervention. So people think of Libya as a hard power operation. It was a smart power operation in which a no-fly zone and arms embargo were only a tiny piece of it. Engage, translated leverage, and these other elements, assets freeze, diplomacy, travel ban, accountability of the ICC was put together, and while Libya is not in a perfect state, it was basically successful. So what happened in Syria? The same effort was done, but there was an ambitious goal: secure chemical weapons, oust Assad, get a ceasefire, humanitarian aid, secure accountability, with smart power alone and no hard power dimension. A Security Council resolution eliminated a threat of force. There was a mismatch, and Obama couldn't get people to accept the notion of a red line, which led to this embarrassing situation last fall. What Obama thought was a red line was crossed. He said, we have to respond. He hadn't gotten the support to do it. And suddenly, everyone started talking about how Obama looks like Bush. Unilateralism, black hole, and going it alone. And they rejected this alternative. But look what happened. We suddenly have, this is so sickening. You know, Vladimir Putin, Mr. International Law, Mr. Soft Power, writing in the New York Times, preaching to us. But look what happened. The threat of force, whether wisely or legally threatened or not, and I think it was legally threatened, created the impetus for negotiations, created a basis to engage our allies. It allowed a translation of the Kosovo precedent into a response to the illegal use of chemical weapons. It leveraged this into a diplomatic process, and it started movement on chemical weapons. Now, by the way, the net result, the LPCW won the Nobel Peace Prize. As of yesterday, 87% of the arsenal has been removed. The rest will be removed by June. So a smart power approach worked. And the debate now, is it legal to arm vetted Syrian rebels? Some lawyers argue no. I think it can be done lawfully depending on who, how, and why. Do they have an imprimatur of legitimacy? To what extent are they acting independently? And to what extent are the outside powers engaged only in a humanitarian motive with no territorial aspiration? And finally, what about Ukraine? This is the basic statement of the U.S. position. Right now, the key element, targeted smart sanctions on plutocrats, multilateral outcasting. Hard power is not a live option, so smart power is the main effort. And meanwhile, the hardliners are saying that Obama is weak. But the real question is, sometimes chemotherapy works when surgery is not available. Is this one of those times? Now, I've been very struck by this because I argued for the independence of Kosovo. I found that my face and my oral argument are on the website of the Kremlin. So you argued for it, so the U.S. is hypocrites. Short answer is no. There are 4 distinctions. First of all, Kosovo was breaking up from a disintegrated country. Ukraine was part of a stable territory, or Crimea was. Gross human rights abuses led to it. This was done in Kosovo within the UN system as opposed to outside. And the ICJ has even said very explicitly that illegal force can invalidate a declaration of independence, and that's essentially what Crimea's quote, treaty and deal with the Russians has accomplished. So let me conclude on this note. Obviously, there's much unfinished business. I should have added under transparency the release of the Senate Select Committee report on torture is a critical aspect of this. But is there an approach that works or can work if you give it enough energy, enough time? Yes, engage, translate, and leverage. So is there a lot of work to be done? Yes. This administration still has 3 years left. So I wouldn't give up on it so soon. But it has to use the tools that are really available to it, and this is Exhibit A. So with that, let me stop.
Okay, we're going to open to questions, and we'll just let you feel real.
Yeah.
Hi, thanks so much for the presentation. I was curious about sort of the discourse of international law and human rights and how sometimes they come together. For example, Mark Zuckerberg, who's launching an initiative, internet.org, and that's the question, is connectivity a human right? So it's also a commercial enterprise. So I was just curious, might be a little bit, off the beaten path of what we're talking about, but I was curious about your opinion of the language of human rights being used by private corporations.
Well, so there's an effort to use the notion of internet freedom as a right to connect. The problem is obviously the right to connect is not unlimited or unregulated, or Osama bin Laden could connect with Khalid Sheikh Mohammed in order to kill somebody and then say it's a First Amendment violation if you try to prevent him from doing so. So obviously that right to connect is subject to constraints, including constraints about security. And also there's obviously some capacity to monitor because people are using public instrumentalities to do so. I mean, in the Fourth Amendment context, the Supreme Court held a long time ago that if someone makes a bet at a telephone booth using a public instrumentality, their reasonable expectation of privacy is not unlimited, right? The only problem now is that the balance between privacy and freedom has to be balanced. And you often have this, remarkable, well, here's a good example. You watch a movie like The Bourne Identity, right? And Matt Damon, who was playing the guy, Bourne, goes from Paris to Tangier, and they show some huge intelligence machine tracking a telephone call as it moves across, right? Well, I mean, that is a result of a collection of bulk data, right? Metadata. They know who called who, right? Now, in the old days, if you went to a series of wired phones and made those calls, those could be overheard in a law enforcement purpose. What scares people there is that this data is gathered, and supposedly the substance is not like that, only the metadata, and it's looked at in non-terrorist situations. And discriminatory rules are applied against foreigners as opposed to U.S. citizens. So, obviously, this old concepts have to be balanced against the new situation. So things like Zuckerberg's idea of freedom to connect, a lot of this is capacity. If Zuckerberg believes in freedom to connect, he should give a lot of money to countries where you can't connect, out of charity, frankly. Be good for him because then they all want to be on Facebook, right? So, I would. There's a difference between a legal concept and a kind of political trope. And I think one good thing about internet freedom is you have rich people pushing for more freedom. But the question is, are they also conscious of the civil rights considerations? You know, Zuckerberg has demonstrated tremendous respect for privacy when it's his own capacity. You know, so if you put in something, here's the irony. You know, we put in information into our Gmail, and the next thing you know, you see an ad for the thing we put in, and they just use that data. But if the government does it, it's much more threatening, even though probably the government's capacity to deal with that information is less than that of a private entity that's organized around manipulating that data. So this requires a lot of thought, and I don't have simple answers. It's just to say that the kinds of crude and frankly pretty simplistic discussions I've heard about it make me think that you just need people who are technical experts, human rights experts, and experts on issues like the technical limits of commercial activities, etc., to all get together in rooms and talk about it. Yeah.
Can you explain how the threat of force is legal under the UN Charter?
Yeah, I think, so I think that I'm with Michael Ignatieff on this one. The UN Charter, force has been threatened dozens of times. And the idea that there is a flat ban on threats of force that not been superseded by state practice just strikes me as Scalia in action. And by the way, in Syria, the same people who argue for the primacy of the Security Council resolution in the name of sovereignty are doing it because those vetoing a resolution is Russia, who obviously cares not a bit about sovereignty, as you see in Crimea. So the only value at stake in the UN turns out not to be sovereignty. It turns out to be both sovereignty, human rights, and other things, those are basic dimensions. So in a broader legal analysis based on object and purpose, the question is, can we define some scope? My view is the threat of force is frankly what keeps diplomacy going. I mean, by the way, we were getting nowhere on chemical weapons until there was a threat of force that got Syria and Russia to the table. And so I think if you say, to me, this is not for the lawyers to take off the table. It's whether policymakers think that this legal option is effective or not. And I think we're back with it again now, right? Assad's not going to negotiate if he thinks he's going to win militarily, right? The trade-off in Syria was that essentially by going the chemical weapons route, it was essentially a concession by the West that Assad could stay and deliver the chemical weapons. So suddenly one of their demands, which is that he leave as a precondition, was effectively dropped. But I think the question is, how do we get out of this box now? I commend to you Ryan Goodman, my friend who's the former Harvard Law professor, wrote a blog on this in Just Security blog, in which he basically argues the threat of force. The notion that threats of force are per se lawful under the wording of Article 2.4 just can't be taken seriously anymore. Yeah.
A question related to the idea of associated forces. Do you think the AUMF was intended to apply to associated forces with no link to the 9/11?
No. No.
And do you think that in that case, Al-Qaeda in the Arabian Peninsula falls under the AUMF and the drone links that can be conducted under domestic law within the framework of the AUMF?
I think Al-Qaeda in the Arabian Peninsula is part of Al-Qaeda. So let me use it. Under the Obama administration, it wasn't true under the Bush administration. The AUMF is construed consistently with the Geneva Convention and the laws of war.
How does it?
Let me finish. So one of those laws is co-belligerency. So if you attack Al-Qaeda, the question is someone a co-belligerent with Al-Qaeda, and that is the sense in which, say, Vichy France became a co-belligerent with Germany. there's a three-part test which has been articulated, which is they entered the conflict alongside the United States against, alongside Al-Qaeda against the United States. Now, AQAP is functionally merged. So, let me give you this example. If the United States declares war on Japan after Pearl Harbor, and a Japanese soldier joins the Japanese army a year later, obviously that person wasn't there on Pearl Harbor, but we've still declared war against them, right? They've joined the original force. And that's the sense in which Al-Qaeda in the Arabian Peninsula is an associated force. The debate under current law goes to Al-Shabaab, right? And there are competing views on Al-Shabaab. One view is, and I reject this view, Al-Shabaab is a full co-belligerent with Al-Qaeda on all issues. If that's so, 3,000 plus Somalis, including Somali Americans from Minnesota, are at war with the United States and are targetable by the U.S. under the AMF. I don't believe that. The alternative is that there are about 12 to 15 people at Al-Shabaab who are co-belligerents. And they've declared this by various legal acts in which they have functionally joined Al-Qaeda. And there are those who meet that test, Abu, for example, is one. Many of the other Somalis are engaged in piracy or other kinds of ad hoc activities. They have no territorial goals to attack the United States. They want to control Mogadishu. So this is the key issue, is that associated forces, if everybody is our enemy, the war will never end. So we have to define our enemy narrowly, and we have to use a strict rule as to who constitutes our enemy. So if somebody says that the guys in Boston Marathon, did they sympathize with Al-Qaeda? Of course. Al-Qaeda successfully did a bombing. That's what they wanted to do. Does that mean they joined Al-Qaeda and were subject to command and control from Zawahiri? No. Right? I once said in a meeting, do we know the difference between the Beatles and the Beatle imitators? There are thousands of Beatle imitators, but we're at war with the Beatles. To my amazement, Obama came out a few weeks ago and said, are we at war with the Los Angeles Lakers, or all the people wearing Los Angeles Lakers jerseys? They're not the same, right? Sympathizers are not members. So this is the key. If, Al-Qaeda core consists of a couple thousand people, many of whom are dead. Al-Qaeda in the Arabian Peninsula is the most active unit. I don't think ISIS is a co-belligerent of Al-Qaeda. The Taliban have been allies, but they have aspirations which may lead to peace negotiations in Afghanistan, and they may drop out of this equation sooner or later as the West disengages from Afghanistan. So whether this war continues will turn on two things: how successful the military operations are against the original group, and how broadly lawyers interpret the word associated forces. And I think they should construe it to mean only genuine co-belligerents, which is not that many people. Now, by the way, this requires intensive factual analysis. When I was a professor at Yale Law School, I knew the names of all my students. I knew their backgrounds, I knew their resumes. For the last 4 years, I knew every senior member of Al-Qaeda. I knew how they joined, I knew what they did, I knew what their first acts were. They were the same age as my students. And there are many days where I wondered, why is it that I have, abandoned a world where 26-year-olds have happy aspirations and want to improve the world to one where I'm studying the resumes of people who dedicate their lives to suicide missions. But if you're serious about distinguishing a lawful killing from an unlawful killing, you have to do that. I had one Al-Qaeda suspect who was born on the same day as my own daughter, the exact same day, she's 28. I tracked his resume, and I just remembered what my own daughter did on those same days. Unbelievable. But it tells you about the differences in the kinds of world we live in. Some people get to go to Harvard, and some people don't. And then you have to decide what's good for human rights. And either way, human rights on both sides of the equation. It was very clear to me, were lives saved because Osama bin Laden died? Very clearly, yes. all he did was plan attacks. And he was pretty good at it, very good at it. In fact, historically good at it. So, in my view, counterterrorism correctly done is a critical piece of the human rights strategy. Here's the irony. For Obama to end the war, he must win against al-Qaeda, which means he must have support to do so. In Afghanistan and Iraq, he can just leave and go home, and they can be reoccupied by the radical forces. But if he doesn't defeat al-Qaeda, then he runs the risk that offshoot groups will come and bomb major Western capitals, and then he cannot claim that he actually defeated them. So it actually requires a kind of war effort brought to conclusion with public support that they've never rallied and that they never produced the transparency for. That's why I gave the example of Al Gore. If Al Gore had said, an irreducible piece of this is war against Osama bin Laden and his colleagues using drones, and I hope to get it over with in the next 3 months, and I won't get distracted, but I do need your support, he might have gotten it done. Instead, here we are, 13 years later. Everyone's confused and everyone's tired. Yeah.
Wanted to get your views on how engage, translate, leverage would apply to the challenges in South China Sea and East China Sea, with all those little islands and at times rocks, with the sovereign territories around them and maritime borders around them, and everything that is going on with that. And there is a lot of international law ambiguity around it. So was just curious how you would think about applying engage, translate, leverage to that.
Well, what you see happening is exactly that strategy. So, China is very aggressively moving both East and South China Sea. They claim that they're essentially law-free zones. They themselves assert a theory of a 9-dash line, which has a U-shaped line, which essentially has no basis in law. They never clarify the scope of their legal claims. And then they send gunboats to occupy little islands and rocks. So when the important development was that a bunch of the countries involved on the other side started to realize they had a collective problem. So Philippines, Brunei, Vietnam, and then in East China Sea, Korea and Japan. So first result was engage. Unilateral declaration, or a declaration at the ASEAN meeting that multilateralizes it. Second, trigger of international dispute resolution. So the Philippines brought a case against China at the International Tribunal for the Law of the Sea. What happened this last week, Obama is in Seoul today. A couple of days ago, he was in Tokyo. What do you say about the Sangha cruise, right? Which is, he asserted again support for the lawful position of Japan, and he called it a rock. And a lot of people didn't know why he was calling it a rock, because the difference between a rock and an island has very great significance under the Law of the Sea Treaty. Now, the greatest irony of all is all this shows why the U.S. should be a party to the Law of the Sea Convention. Because we now desperately need those concepts to help us in this struggle. And the people who are keeping us out of the Law of the Sea Treaty are members of Congress who see it as a sacrifice of our sovereignty. And to them I say, because of your protection of our sovereignty, we're losing the South China Sea to China, the East China Sea to China, and the Arctic to Russia. And those are the people you hate the most. And you're the people who say that in the name of international law, if international law threatens our sovereignty, guess what? International law is the tool that you are depriving from our smart power package. And you call yourself states. I call you something else. Not states. Is that a good answer to your question?
Yeah, thanks.
Yeah.
Thank you for being here and for your presentation and answers. I have a question relating to the notion of liquid black holes that you presented. In U.S. courts, the government often relies on doctrines such as the political question doctrine or state secret privilege that effectively prevent the U.S. judiciary from reviewing executive position when it comes to national security and foreign relations. And including cases that touch on constitutional rights, such as the killing of witnesses. So I hope to hear your perspective on these doctrines and whether they also constitute a legal black hole in rights.
Well, to be a black hole, it has to be everywhere. And the fact that I wrote about this 20 years ago. And we had a case called the Haitian refugee case, which we lost at the U.S. Supreme Court. And my view on this is, guess what? It's not over. There's something called transnational legal process. You can relitigate this issue in many other forms. And the issue of extraterritorial application of refugee law has been litigated all over the place, including most recently at the European Court of Human Rights in the Hersey case. And they found as a matter of European human rights law that the convention applies. But guess what? The United States courts are not the last word. Surprise. I mean, in the United States, the New York courts are not the last word either. You know, so when you're part of a group of nation states that have a collaborative legal framework, other countries get to decide too. Which means, so, you know, the United States might think all issues related to CIA black sites are not reviewable. But it turns out that Poland or Romania can get taken to the European Court of Human Rights and they're subject to judicial review, right? It could be the United States doesn't want to review drone standards in courts, and guess what? They'll be reviewed in another court. So judicial review will happen, and the question is, will it happen first in the United States or later? So one of the developments in international law, and this goes to my friend's point here, is that the clarity of rules. I mean, we didn't get to a world government in 1945. We have a much more complex structure. On the other hand, we have many, many more forums and interpreters, which means that if you provoke interactions that lead to interpretations, that lead to norm internalization, you can get to legal principles. Now, Catherine Zicking treats this as part of a much broader political spiral. My part is the legal piece of it. The fact of the matter is that different kinds of norms, there can be challenged to those norms and try to oust them, and then efforts to reassert them. And that effort doesn't turn just on the courts of any one country, right? I mean, by the way, will the integration of Crimea into Russia be upheld in the Russian courts? Of course it will, right? But if you refer that to the International Court of Justice in The Hague, will it be upheld? Probably not. So in other words, there are many, many more avenues to pursue legal remedies and legal clarification in these contested cases. Yes? Oh, I'm sorry. Yes.
My question is about the International Criminal Court. So I appreciate that there's been a pretty dramatic shift between the Bush to the Obama administration on the ICC, but I think that referrals from the Security Council and rhetorical support of the Rome Statute haven't really helped the ICC very much, because what it needs these days is more money and arrests. Is there ways for the U.S. to support the ICC in more practical, meaningful ways beyond referrals that are possible within this political climate, or is it just going to have to stop there?
So I apologize. I think the ICC has enough money. What they need is a prosecutorial strategy that makes sense. Here, prosecutors to carry out their policy. The ICC has the prosecutor's office has a very mixed record, and frankly, they're coasting. They have one conviction in 10 years, and they're claiming the accomplishments of the ICTY as their accomplishments, and that's fine for a little while, but they've got to start producing some results. And I think the point for the ICC to blame outsiders for their own internal failings is over. ICC has to be a better court than it is. It needs to have a better prosecutorial team. It needs to have better judgments, and it needs to bring cases that aren't counterproductive. And so my view, and I've stated this in many, many public forums, is the ICC is like a wobbly bicycle. It's riding along now. It has 110, 113 ratifications. It should get stronger, but it shouldn't put too much weight on itself. And for example, something like a Palestine referral, clearly outside the scope of their jurisdiction, get rid of it. I mean, does anybody think it's a good idea to criminalize the Middle East peace process? Is that good for anybody? Is that good for the ICC? You know, In other words, the ICC needs to adopt an approach of doing contained matters well and successfully and build up a track record. Frankly, they've had too much talking by prosecutors and not enough rulings by the court. Yeah.
You spoke a little bit earlier about how technological advancements have outstripped, I suppose, the evolution of human rights frameworks, and that human rights frameworks need to catch up. So given that technological advancements are occurring at an increasing rate, I was wondering if you could comment on what the international legal framework or what the human rights framework can do to more proactively evolve and respond to future potential crises in lawlessness in these industries or markets that are occurring as a result of technological innovation.
So I think the Human Rights Council, while not without a flaw, is taking on some of these issues and developing soft law to address it. I mean, my approach is simple. Translate. Engage, translate, and leverage, which is, there are principles of law that can be developed that apply to these new situations, but other people might not agree with it. For example, I thought it was pretty clear that someone carries a 9-month baby to term has a natural relationship, and I got a lot of resistance from people who said, genetic relationships you can test by DNA, but you can't test the gestational relationship, so it induces fraud, et cetera, et cetera. You have to balance these things out. But if you come up with a standard, like a standard on drones, or a standard on cyberspace, or a standard that balances freedom to connect versus cybersecurity, then the question is how to take it to a group of countries that are committed to the rule of law, have them put out soft law standards, and then have that be the basis of discussion, particularly with countries who would prefer the black hole approach. But that's why the key is the difference between translating and a black hole. If you're trying to apply a principle of law, there's a world of difference between that and saying no law applies. Because if no law applies, then as Thucydides would say, the strong do what they can, the weak suffer what they must, because it's a law-free zone. And I come to a very basic conclusion, which is, international law has developed over thousands of years now. And the fact of the matter is, we have moved to a point at which many issues have been seen before, and we ought to be able, through human intelligence, to treat these intellectual constructs as having a kind of power that makes resort to naked power less necessary. And that means being creative. But, we're not in a world of world government, and we're not in a state of nature. And the goal then is to do what Kant said, which is to have law-abiding nations collaborate, and then law-abiding private entities collaborate. And the goal and the hope is that you get a world that is dominated by principles of law and not just force.
We had Mama was going to end at 2:30, but if you want to take one or two more questions, then that's up to you. So.
I got nothing but time.
Okay.
I don't think the Red Sox are playing, they're not at home.
So I'll take a couple more questions.
That's sad, they're not at home. Yeah, got here.
Thank you. What does it mean to be a human rights lawyer when the law itself doesn't necessarily reflect human rights, and in some cases seems to actually impinge upon human rights, as in the case of monstrous prison practices in Abu Ghraib, which then would seem to encourage American hatred in Afghanistan, which would then increase the likelihood of Afghanis entering Al-Qaeda, as opposed to taking a more proactive approach, which would be encouraging, maybe a more better structure within Afghanistan that would reduce American hatred.
Well, I put it this way, when you're in a flood zone, Hurricane Katrina, and the waters are high, your main goal is just bringing down the water level. At a certain point, structures and things below the surface start to appear. The good news is you brought the water level down. The bad news is the world is more complicated than we thought. So guess what? The human rights movement has been successful. It's changed the discourse of modern international law. It's caused a reevaluation of concepts of sovereignty. That's the good news. Everyone speaks in the rubric of human rights. The bad news is it turns out that on many issues that we face today, second order, third order human rights questions, human rights are on both sides of the equation, right? I mean, if I prosecute Sanusi, the Libyan intelligence chief in a Libyan court, it's a vindication of human rights on the prosecutorial side because he arguably killed many people. But he has human rights of his own. So human rights is on both sides of the equation. Or if I encourage military intervention in Syria to stop killing, that might itself lead to some killing. So human rights are on both sides of the equation. And the question is, which is the greater good or lesser evil? Not to say. Or, counterterrorism is a good example of this. So was it appropriate to respond to 9/11 in certain ways? Yes. But are there things that would have worked, that would have built legitimacy rather than sacrifice legitimacy? Clearly, right? Could we have had constrained detention policies? Who was the genius who said open Guantanamo? But they were at that point in a panic. And Abu Ghraib didn't come out. By the way, the one fortunate thing about Abu Ghraib is that those revelations came out as they were arguing the Guantanamo cases at the Supreme Court. And they suddenly realized that a policy of hands-off and over-deference to detention can license grotesque abuse by people who have no awareness of the Geneva Conventions. And that's what led to the situation we are now. My view, by the way, now is I don't think Guantanamo is illegal. I mean, I've been to Guantanamo many, many times. I've never seen Guantanamo more rights aware. But guess what? It's a terrible, terrible idea. It shouldn't exist anymore. The United States shouldn't be holding enemies of the state offshore. It doesn't matter at the cost of $1 million a person a year. I mean, what message does that send? So are their Geneva Convention rights being respected? Yeah. And then you have situations where they do things like have hunger strikes. And what do you expect? If people are there forever and they have no expectation for how to get out, you're going to have a series of third and fourth order disputes. All the more reason to close Guantanamo. Not under court order, but because it's the smart thing to do. So I think that's the tough part that we face here. The irony is that what may end up closing Guantanamo is the expense. I mean, it's crazy, but through some calculations, each detainee at Guantanamo costs the United States $2.5 million a year. And if you brought them to a prison of the kind that held Timothy McVeigh, who killed thousands of people unquestionably, it costs $35,000 a year. So what's the explanation? How can you justify it? And there are members of Congress who care about nothing but the budgetary aspects, and that's what's, I think, getting their attention. Yes.
Yeah. Actually, there was very tragic ferry accidents in Korea. So a lot of students are dead and missing. So many people actually observed that the government is trying to rescue the students. So some people try to understand the situation, saying that this is because bureaucratic systems. So they don't want to take the responsibility and they don't want to take the cost to rescue or something. At the same time, what is not broadcasted by media is that students and family members actually from kind of a relatively poorer locations, poorer area. They are not from the richer locations here or inside Seoul area. So many Koreans actually very much disappointed at the same time. They don't know how to understand these kind of situations because governments actually kind of they don't care about their people. So even all the kind of a Korean situation all the time, dynamic at the same time, all the time straightened from those there are some kind of a diplomatic complex situation. So many Korean people actually live in sorrow and how to understand, they don't know how to understand current situations. So it is this kind of some transition period in terms of Western society also experience these kind of things, and then they develop, they improve the government officers' mindset or
how to treat their people in terms of human rights something. So I like this kind of.
Yeah, obviously I'm a Korean American. My father was from Jeju Island. We rode the ferries many times. I remember riding the ferries and being shocked by the condition of the ferries, which were well below regulatory standards that you would expect for, say, Staten Island ferries. Obviously, we're past the point at which so in South Korea there are several levels. First, the recognition that civil and political rights apply. And in the period of economic development, export-led growth under Park Chung-hee, people like Park Chung-hee would say, you can worry about human rights when you have $100 a year of GDP. But, it turns out the first Nobel Prize winner from Korea is a human rights hero, Kim Dae-jung. And it turns out the Koreans have accepted the values of this human rights system. Now, it turns out that in this human rights system they've accepted, thus suggesting it's not just a Western construct. It's not just the duty of the government not to torture people or not throw them in jail. There is some duty of the government to organize itself to respect these rights. And it may also be the right of the responsibility of the government to champion these rights. I gave this example in the tobacco case. If the government is aggressive in stopping people from being tortured, and then does nothing, and thousands of people smoke, get addicted, and die, then is that a failure of governmental responsibility? I think it is. Particularly when the government has a duty to preserve public health, and the government can be expected to act proactively in that regard. So I think what you're seeing now, and with Park Chung-hee's daughter now the president, it's quite graphic, is there's a third stage in Korea's engagement with the human rights system. Stage one was accepting that it's a universal value. Second, the movement away from negative to positive rights. And now third is demanding explanations from the government for sins of omission. So I think it is quite a significant moment there.
We want to thank Harold Koch very, very much.